Well, it's interesting. Speaking of interesting collusion between the government and the media, more evidence of the insanity of the Whitmer entrapment case came out this week as the defendants moved to dismiss the case entirely on governmental misconduct grounds and entrapment as a matter of law because the facts keep getting more and more extraordinary. And that was another example we did at the time when other people were not, was that this case smacked of entrapment, and it turns out to be even worse than some of its harshest critics thought it could be.
I'll lay down the facts because I don't know the latest updates. Governor Whitmer, allegedly a plot to kidnap Governor Whitmer. And when we first heard about it, 6 people were arrested. I'm not saying this to be mean people, and there's no but to this either. They looked like people who would be easy to frame. And I'll leave it at that. Mm-hmm. They looked like easily exploitable people, both for demographics, both for stereotypes, whatever. And we talked about it at first, and we was like, okay, it looks convenient, politically timed, conveniently timed, and we had a discussion. And I remember having a discussion with someone in my personal private circle, who I will not ever mention, says, watch out, when you have these discussions, you lend ideas that, that will empower, promote conspiracy theories. Like, dude, but you need to know this stuff before you can make a comment. And then lo and behold, there were, I think, 12 or 13 people arrested. We now know that there were at least 12 to 14 informants. There were paid informants. There were FBI agents. There were more people involved in either investigating, promoting, orchestrating, and planning this event than actual people willing to participate in this event. And it's come out more and more over time. Great reporting being done on this, fudging the line. When is it infiltration versus when is it entrapment or orchestration? And it only got worse, I guess, Robert. What's the latest in the Governor Whitmer alleged kidnapping plot?
So they've moved to dismiss it on two grounds, that it's entrapment as a matter of law, that the court can find that under the facts as have been developed. And then secondly, that it's a case of outrageous government misconduct. It's very hard to get dismissals on either one of those grounds, but dismissals have been granted in the past on those grounds. Now, what really stands out in this particular instance is the degree and of detail of facts that they have. Basically, it's like that meme where you have a tall character with a big stick and he keeps trying to get the small character to do something, and they impose different things on it. But like at one point it was the FBI trying to get, a little Pepe to, come on, do a little insurrection for me. Come on, that kind of thing. Well, it turns out that basically every time the FBI informant brought up the idea in 4 minutes, brought up the idea of kidnapping Whitmer, the other people that are being charged kept saying, no, that's a dumb idea. We're not interested in that. That's going to cause problems. No, well, why would we do that? So they kept pushing and pushing and pushing. And it really is now clear that not only was this a case of entrapment in general, it's a case that there never would have been any attempted kidnapping but for, or even a thought of kidnapping, but for the government informants. Because it wasn't just that they came up with the idea, it kept getting rejected by the other so-called criminals. And they kept, no, you got to do it. No, you got to do it. No, you got to do it. It was the FBI created a crime to catch themselves, like that Spider-Man meme.
No, that's you went with the be more funny, be more insurrectionist meme. I was going with Spider-Man pointing at Spider-Man, saying, "You're FBI." No, you're FBI. It's atrocious. It's atrocious. What was the other? Oh, no, it leaks into January 6th. What you're describing, Robert, is, hey, guys, you want to go out and kidnap Whitmer? Not really. I could think of, I'd rather go fishing, but you really want to do. And then you got going to January 6th. You have the video. The Revolver did an investigative piece. It's amazing. You have people. If I had to guess who looked like CIA or intelligence, I wouldn't know. But apparently the crowd did, because they were literally chanting, Fed, 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 when the guy was saying, we're going to storm the Capitol. And the crowd says, they used the R word, which I don't use because it's cancelable. They said, dude, that's R-E-T, and then carry it on. We're not doing that. And they says, no, we're going to storm it peacefully. And then the crowd was chanting, Fed, Fed, Fed. And lo and behold, I think this guy's name is Ray Epps or Ray Ebbs. An instigator not being charged with the events of Jan 6, who by all accounts was the one leading it, literally with a bullhorn, or at least one of 3 bullhorns. That's what you got in Whitmer. You have literally people saying, who wants to do this? We have a good life. It's a modest life. We have a good life. We don't want to do this. And then they get duped into it. What's the protocol for that type of motion to dismiss for entrapment? Like, do they suspend the trial? Have separate pleadings? Is it written pleadings? How would it work?
Well, they've already brought the motion to dismiss in the briefing, so the government will respond. They'll get a chance to reply. Presumably, there'll be an oral argument. If evidence is disputed, there'll be an evidentiary hearing, and it's up to the court. I mean, if the court was being conscientious about this, it would dismiss, because this is entrapment as a matter of law. This is also outrageous government misconduct. As a general rule, courts defer to juries in this context, which I don't think they should do, but it's what they do. But I mean, it's yeah, I get it. Yeah, exactly.
You said doo-doo.
Yeah, exactly. That's what this whole case is. That's what this whole case it is. What we predicted from the get-go has been proven true in spades. And it's extraordinary. It's one of the worst, most egregious entrapment cases. And is it a coincidence that key people connected to it ended up being part of the January 6th investigation by the FBI? I mean, you really have to raise questions about all of this. And there was more transition into the January 6th case.
Hold on a second before you get there. First of all, everyone out there, if I hear Robert say doo-doo, I'm making a doo-doo joke. And if I hear him say duty, I'm still going to make a duty joke. Viva, and this is interesting. This is important. I think I might be wrong, and you might be right, Greg UW. You use black pill too literally. Black pill means no hope, no possibility of a positive outcome in your mind, complete doom, no possibility for betterment, not something I see. I appreciate that, which is why I should not use black pill ever, because I don't think I have black pill in my body. I do think there will... I don't think that I don't have a black pill.
The future of Canada.
Well, even then, I still have my red pill or my white pill, which is a canoe and
living
a body
in a cabin way out in the woods.
I'm just saying a canoe and a body of water that traverses one from tyranny to freedom. But okay, no, so. People have to appreciate what's going on in the Whitmer case. I'm going to go I've got to do 2 follow-ups this week. One on Project Veritas, the judgment, and 2 on Whitmer now, because that's nuts. But it goes right into Jan 6. And the Jan 6, I mean, you read the Revolver article. I don't know when I did the video on that. I don't know what day of the week it is anymore. But that Revolver, I mean, the magazine is described as a conservative or liberty-loving liberal magazine. Write it off however you want. Write off the hyperbole in the descriptions as what they were doing versus how they were doing it. You can read the article and say, "Oh, I see bias." Fine. Facts are facts. And when you have multiple unindicted co-conspirators who were arguably, but not arguably, the most active, prolific, domineering actors in this play who are erased from FBI watch lists and not prosecuted. Robert, how do you make sense of any of it? Who is Ray Epps? Who's B Civil guy? Who's the dude on the bus with the Never Trump that gets pulled over the day before for firearms and weapons that we never heard of? How does this happen? What do you make of it?
Yeah, I mean, if people had seen the first hush hush at vivabarneslaw.locals.com, it was about this and predicted this over almost a year ago to the date. Which was that this had the same hallmarks as the Whitmer case, that there was some other sourcing involved or complicit parties in terms of accountability or responsibility for what occurred than what the institutional media narrative was. And Darren Beatty, who's the editor and founder of Revolver, along with Julie Kelly at American Greatness, have gone to great lengths to document and detail this and show this every place that they can. And now Darren Beatty is friends with Amanda Milius, the movie director, documentary director, Plot Against the President, which was also helped predict some aspects of this. If you had followed it or watched it, a very good documentary that we recommend. It's not a surprise that they're hiding a lot of intel, they're hiding a lot of information, they're coercing pleas with barbaric conditions that people are under detention for. I mean, so much so that foreign governments like Russia are making fun of us for the conditions in which we've locked up people in the January 6 cases.
As they should, because the Jan 6 business, I will not say black pill now, that's a red pill, because when you find out what they've been doing to those people, who they've been locking up, someone on one of the videos said, Viva, less propaganda, more facts. You focus too much on the grandma getting locked up. I think, first of all, that's a fact. And they locked up a literal grandma, more than one. But, the 3 instigators, The guy on the tower saying, move forward. The guy, Ray Epps, who's basically the night before doing this entire thing. The dude in the black shirt who's on a bus that says stop the steal the day before. Dude, if there's going to be an FBI hippie bus that's undercover, it's going to look like that bus, which is a school bus spray painted with stop the steal, go Trump, go, or Trump 2020, whatever it was. I lost my thought.
I got journalists who are embedded with people that seem to know things in advance.
Oh, yeah.
So it's extraordinary. And then you have all this video footage that they're hiding. Just a little bit of it came out. It looks like, again, the people that died that day died at the hands of law enforcement. Not only the Ashley Babbitt case, but now it looks like someone else may have actually not died from natural causes, but from Capitol Police physically assaulting the individual. And that's from a Julie Kelly story that's in American Greatness this week. And again, there's 14,000 hours of footage still unavailable to the defendants, who have now been in jail now for a year, going on a year, full year, without basic rights and without basic remedies available to them. I mean, and being treated under barbaric, torturous conditions while they're denied access to the evidence that they need to defend themselves. And with more and more evidence that this was all one big entrapment plot and one big political trial.
It's an amazing thing where it was in the... Oh, it actually goes back to the Let's Go Brandon Dad, where someone accused me of having a double standard because when Tucker Carlson was accosted by that guy in the fishing store, I said, it's amazing that the internet could figure out that this guy was related to intelligence within 20 minutes. And then someone said, oh, Viva, you support doxing when they go after Tucker, but not when, they insult the president. And I said, first of all, what I found amazing was not that they doxed the guy, was that the aggregate knowledge of the internet could find out that this guy who accosted Tucker in a fishing shop was related to intelligence. And you go to the Jan 6 incident, where they have, I don't know how many tens of thousands of hours, how many thousands of hours of video footage they have that they have not released. And that they have not made public. Because if they make it public, you would get every weaponized researcher on the internet doing what Revolver did with what they had publicly available, which is tying all of these players into actual locations, actions, and misconduct the day of. And Revolver did that despite all this stuff not being publicized, despite all the video not being released. And if they did that, the knowledge of the internet would not dox these individuals and say where grandma worked so you can go, ruin her life, but rather who are the players and what are their connections? And how and when is that info? Are those videos ever going to get released?
We don't know. I mean, I think they're hoping to coerce everybody into pleas, and so that they don't ever have to release it. And the only people that go to trial have the degree of sophisticated representation such that they demand it as a precondition of access to conducting a trial. And this all comes in the context of the January 6th committee issuing wide-ranging subpoenas for people's financial information, telephone records, the records of journalists, the records of members of the press, the records of vendors, the records of people connected to the president, the records of anybody connected to nonprofits that opposed any aspect of the election. They're using it as a pretext to do a massive information intel gathering, and to such a degree that now there's, I think over a dozen lawsuits have been filed challenging these subpoenas. And you have federal prosecutors former federal prosecutors who are now media legal commentators and law professors like Barb McQuaid and some others out there misstating what the law is. They're saying, any record in the possession or custody of a third party, you have no right of privacy, no right to oppose. We can seize it anytime we want it for the government. That is not the law. That has never been the law. There is no general third-party exception universally applied. It's very contingent and conditional. And in this precise context, you have the absolute right to file. In fact, it's the only time you can contest a subpoena to Congress is when it is to a third party, because those are your records, and you get to contest whether Congress even has the power to issue that subpoena, whether that committee has the power to do so, whether they conform to congressional rules, whether it's limited to a legislative purpose, and whether it violates other constitutional rights, because the Fourth Amendment applies to Congress just like it does every other part of government. Which these people are trying to pretend it doesn't. But it gives you an idea of the scary scope of it. You have these kind of legal commentators out there saying things like, if it's in a third party's possessions, we can come seize it, steal it anytime we want. And that was a high-ranking national security prosecutor, now high-ranking law professor and media commentator, saying this kind of dangerous stuff. But at least there's a massive fight back and pushback by a wide range of people whose records are being looked at. But the fact that it's financial records, bank records, phone records, email records, clearly they're trying to put a map together. Anybody who opposed the election on the grounds that anybody who opposed issues related to the election was part of the January 6th insurrection. And that comes into the latest coup attempt by the most corrupt elections lawyer in America, one Mark Elias, who left Perkins Co. under suspicious circumstances. Mr. Elias, who's been sanctioned for his frivolous activities in election law just within the last year, is plotting with Democrats to try to misuse the 14th Amendment to keep control of the House in 2023 by expelling anybody they think was part of the insurrection under the 14th Amendment by a complete misapplication of that law.
We're going to get there in 30 seconds. I just want to bring this one up. First super chat, you two are our go-to tune-in. Please tell us, not viewers, how you two have started collaborating. Don Bonice, put in the terms Viva, Fry, and Barnes, and then organize it by chronological order. You'll see our first stream. It started with salmon, and my goodness, has it blossomed into something beautiful. David, you must try Viva Chicken. No, if I can get one day, my first taste of freedom will be Viva Chicken.
There's also some sort of new drink, Viva Tequila. So I was like, yeah, that might be an interesting sponsor, Viva Tequila.
I hope Mateo is not being serious here. You better be sarcastic, Mateo. Robert, when I did cut you off, it was about the congressional hearings. Oh, so sorry. What they want to do with just get back to the congressional thing for a second. This congressional Jan 6 committee, bipartisan, being led by Dick Cheney's wife. Can we stop with
his daughter?
His daughter. Sorry. Did Dick Cheney shoot somebody on purpose, or was it an accident when he went duck hunting?
No, nobody knows. I think he shot him in the face. So the guy had a Darth Vader reputation for a reason.
Okay, so it's Liz Cheney. It's his daughter. She's the Republican on this committee. Robert, I know I learned from you, but then people are going to accuse me of just parroting what you're saying. These congressional committees, why do they exist? What is their purpose? Because some people are saying, good, the congressional committee should investigate wrongdoing by their political adversaries. But my understanding is that's never what the congressional committees were intended to be for. So what are they history-wise, and how are they being abused?
They're the legislative branch. So in the past, when they've tried to hold people in contempt and actually try to arrest people, they were able to sue the sergeant, and they said they sued under the Speech and Immunities Clause, but their agents were not. So the sergeant-at-arms was not immune for his false imprisonment claim because they said Congress has no contempt power. That's just a judicial power. The same is true of these subpoena powers, just a judicial and executive power. And I don't think they should have ever been allowed to have subpoena power, period. But the court said, yes, you have subpoena power for the purposes of investigating issues necessary for pending legislation. I always had a problem with that. That was an invitation to trouble. To the degree they wanted the legislative branch wanted to hold the executive branch accountable in some ways, frankly, that's what the impeachment power, I thought, was for. And maybe pursuant to that, you could issue subpoenas, but not just general subpoena power. Well, the current limitation constitutionally the courts have imposed is that it has to have a nexus to legislation. And that means, and also it has to be a legitimate committee. And here there's major problems of whether or not it's a legitimate committee.
The nexus to legislation, where is that written? Where is that in the rule book?
So that's just the Supreme Court has said, yeah, we're going to say that Congress, as a legislative branch, has the powers of the executive and judicial branch in issuing subpoenas. And we're going to say that if you're the one subpoenaed, you can't even fight it in the courts like you can every other subpoena on the planet Earth. So, I had problems with both of those rulings, but that's where the court said. But then they said, but don't worry, we won't allow this to be abused because it can only be done for legislative purposes. Can't be used to target people, can't be used as a bill of attainder, which is prohibited under the Constitution, can't be used to punish people. There is no right of legislative punishment, what a bill of attainder is about. And so don't worry about that. That's the limitation. And most of the time, Congress actually does stick with that. This committee was formed clearly for legislative purposes. If it was for legislation, they would have assigned it to an existing committee. They created a special committee, and they didn't even abide by the terms of that committee. The members of, Congress voted on those terms. It said it had to have a certain number of minority members. The minority members had to be in consultation with the minority leader. They had to have a ranking minority member. It has none of those things because Pelosi didn't want to go along with who they wanted, who the Republicans wanted on the committee. She didn't want Jim Jordan on it or anyone else. And so she decided to do something that's never been done in my knowledge in the history of Congress, which is to completely ignore the minority party and completely ignore all the rules of the committee's own creation. And historically, the way that's enforceable is they don't have subpoena power then because they're not a legitimately formed subcommittee of Congress in the way that subpoenas are issued. Now, whether these courts are going to care is an open question. I think, unfortunately, we'll see politics again come in play. But hopefully somebody steps into the breach at some point and puts a limit to this circus because that's increasingly what it looks like. And some of us said this was inevitable once the courts gave Congress this power in the first place. They should have dramatically limited this to impeachment only or when they're exercising judicial authority as they have limited, like in impeachment, under the Constitution to do. In every other context, they don't, and I don't think they should have ever had this authority.
And I'm going to say one thing. When you say doo-doo, I think of doo-doo. When you say duties, I think of duties. And when you say subpoenas, I think of something else. So I hear the word in my head because I'm a sick person. Robert, are you involved in any of the Jan 6 litigation?
Not yet. I mean, the significant problem is they have nowhere near the resources necessary to mount a competent defense. You're talking about 14,000 hours of video that have to be reviewed. Just do the math on that. I mean, that's 7 people working full time for a year to see it all, right? I mean, so the average lawyer or legal assistant bills 2,000 hours a year. Yeah, I mean, that's on the high side. A lot of them bill less than that. So, when you're because that's 40 hours a week, 50 weeks a year. So given that, I think that's the hard part. I mean, it would take what I have recommended to people is that there be some centralized like amicus type that helps everybody but doesn't represent anybody. Because once you represent one person, you're conflicted in representing a whole bunch of other people. So what would be easier is if there was one central place where everybody's forming templated briefs, templated motions, templated discovery requests, is reviewing all of the information and providing detailed insights about it. And I think that'd be a more effective way to coordinate. There's very few historical examples like this of a politically motivated prosecution where thousands of people are being targeted for criminal prosecution. That's very unusual. And all of them broke, basically.
And Mimi says, thank God for you guys. I got to tell you, Robert, like my white pill moment was on the Jan 6 when it happened. And we were talking, and then we did a stream. I think it was the day of. And
yeah, that night. Because I was in D.C. Luckily, I did not go.
And you mentioned that,
I was invited to attend another thing by some high-ranking White House people. And that was why we watched it all unfold on screen.
And I'm saying if we're black-pilled, Robert, some might say you were invited for nefarious purposes. Get you on a no-fly list.
People might have wanted me down there for that reason. That's absolutely true. But I didn't. Good for Alex Jones. He went down there to try to stop people from doing it, and yet it hasn't stopped them from harassing him and harassing people connected to him. I mean, Owen Schroyer's facing completely ludicrous charges related to this, solely to smear Alex Jones because they know he was one of the key people that stopped it from getting bad or from getting much worse than it otherwise would have. And then the only reason that they probably never expected that because so many people have a caricature of Alex Jones. They think he's the character from Homeland when he's nothing like that at all. And so it was probably his people that night calling out that guy as a Fed.
Yeah, well, that was calling out that guy as a Fed was hilarious because this is a guy in a crowd. It would never be my reflex to call out somebody as a Fed. They did it. I want to bring this up because AJ Cook says, check my exclusive at National File. We broke the diary story too, where I published video of Sean McHugh organizing Jan 6 breach. In custody, but not for conspiracy, no MAGA connection, but has conviction for statutory. AJ Cook, let's screenshot this. Boom. Very interesting.
Yeah, there's a lot of. The public defenders are trying to bring in people from outside to help. People. There needs to be sort of one central location for a lot of this. The Viking, that guy got a harsh sentence. And I agree that the court's eagerness, all these liberal judges in particular in D.C., their eagerness to punish these people is discouraging and deterring the DOJ's goal of having them all plea without ever seeing discovery. And so even though the rules, by the way, in D.C. are that you're supposed to provide the discovery material in order to be able to meaningfully plead, but I think it's incredible the scale of what's happening. But that transitions into Mark Elias's idea.
Robert, just so everybody knows what I was just doing, this is as Canadian as it gets. I took off my boots because my feet are warm enough now, so I took off my boots. Oh my goodness, that's what I was doing under the table. But sorry, Robert. If people want to help the Jan 6, like I'm almost reluctant to ask the question because it's asking how they can help.
I don't know of one right now. I know Matt Brainerd was doing some stuff. I know Julie Kelly was trying to do some stuff. I know some other people were trying, but I don't know of one right now that has what I'm talking about. So and I've been focused on the vaccine cases, so that's consumed most of my spare time. People have reached out to me on January 6th. The problem with representing any one individual is that can create conflicts where you can't represent anyone else. And it's clear that the people that are reaching out, the cost of doing this kind of defense is frankly very, very high if it's going to be competent. So that's the problem. There's no way any of them have the means to it. So I'm trying to figure out some alternative solution that could meet everybody's concerns. So we'll see. I know John Pierce is representing some people. I have no confidence in John Pierce still. That hasn't changed any. But it does. I mean, you see the political nature of it and what's happening with the committee and what's happening with the grand jury and what's happening with these criminal cases and what's happening with how they're being treated in jail. In that you have a guy like Mark Elias using it as a pure pretext to try to seize control of Congress, saying they're going to accuse random Republicans or whatever Republicans they want of being insurrectionists or of aiding and abetting an insurrection and invoke the 14th Amendment to prohibit them from sitting in Congress.
I try not to get blackpilled, but this is where I might get blackpilled when I see people trying to do this. But I want to bring this one up. Theo Faster says, I have zero sympathy for a Jan 6 rioter, but a grandma taking pictures with a flip phone and walking quietly through the Capitol? Well, Theo Faster 3.0, then you do have sympathy for a Jan 6 rioter because a Jan 6 rioter. Yeah. But Robert, so Mark Elias now is basically trying to say, any politician who doesn't do what we say they have to do about this, decry it, dissociate from it, condemn it, lock them up. If you oppose us trying to bring down the hammer of the law, you're one of them. How is this not McCarthyism? How is this not McCarthyism in real time?
No doubt, and it shows where the left is, that they only care about power, that they're embracing this idea, because outside of the Civil War context, the only other time this has been invoked was to target critics of war, people that were wrongfully convicted under the Espionage Act because of its misapplication. I mean, it was used to lock up Eugene V. Debs, for crying out loud, just for opposing World War I, a war another one of the wars we entered based on lies. But so it's a bad idea in the first place. But I mean, although what the 14th Amendment said is under Section 3 that somebody that had joined the insurrection or rebellion could not have a position of power unless 2/3 of Congress said they could. That's all that. It was clearly applicable to a very limited historical context. And the idea that, and in fact, at the time, the Supreme Court, in a circuit opinion, not a binding opinion, because back then individual justices rode circuit, so they would issue solo opinions. But it was the Chief Justice, Samuel Chase, said that this was not a self-enforcing provision, and said, in fact, so the only clear law on this says that you have to have been criminally convicted of rebellion or insurrection. And even then, you have additional due process rights before you can be removed or denied office. That was a case, you can imagine the implications. What happened was, after the Civil War, you had states that didn't have functional governments to a certain degree. To what degree the governments existed, you had Confederate officials presiding over. So you had a bunch of people that got convicted of crimes. And some smart lawyer said, you know what? That judge who convicted us was part of the Confederacy. And under the 14th Amendment, they don't have the power of office anymore. So they brought habeas petitions and said all our convictions are invalid because that guy was part of the Confederacy. And in the 14th Amendment, when he made his ruling, he was one of those disbarred officials, if you will. And they, of course, for practical reasons, there was no way the U.S. Supreme Court was going to go along with that because they weren't going to free every criminal who got jailed from 1866 to 1868. And so Justice Chase came in and said, no, that isn't what that means. That's not a self-executing, self-enforcing provision. Somebody has to be criminally convicted of rebellion or insurrection first, and even then they have to have due process. A legislature by itself couldn't even do this, so on and so forth. So that's the only case law that's out there. And it totally rebuts everything Mark Elias and Harry Litman and some of these other lefty lawyers are out there saying, oh, we can just by a majority vote say that anybody we don't like that we're going to accuse of aiding and abetting the insurrection can't sit in the House. And this has also been litigated in a second context, which is it was originally, by the way, it was writs of quo warranto. I can't, it's like WARRANTO, so it's a little tongue twister. But which people were actually asking about that in the elections contest, but that's tough to get in ways that people thought were it was not as achievable as people thought. But there were special laws written to try to deal with this after the Civil War, to deal with the issues raised by the Supreme Court justice. The other context in which this arose was Adam Clayton Powell. They tried to get around expelling him because the House agreed that they could only expel somebody for something they did while they were a member of the House, not for something before they were a member of the House. So they decided, well, we can just not seat him. We can exclude him, the power of exclusion rather than the power of expulsion. U.S. Supreme Court said you can only exclude someone for the limited listed grounds of qualifications in the Constitution, age, citizenship, residency, etc. Arguably, this Section 3 doesn't apply to that. That Section 3 would be grounds for expulsion, and what's important about that is that requires 2/3 vote. What Mark Elias is trying to do is misapply the Section 3 of the 14th Amendment. So by mere majority vote, they can exclude anyone they don't like and claim they were aiding and abetting an insurrection. It's utterly unconstitutional what he's talking about, but it shows how dangerous he and Democratic lawyers are if they ever get control and power. By the way, you're on mute.
Yeah, because I had to cough, and I don't want to start rumors, although I may have to pee and start another rumor. But Robert, so someone had said, why did Trump hasn't spent a penny on helping these people, and I brought this up because I think this is a very on-point answer. Andrew, Trump can't give the money because he would be aiding and abetting if they charge anyone with insurrection, and that will preclude him from running the House.
It probably doesn't apply to the presidency. They would have to convict and impeach, which they failed to do. And I don't think that's why he's not. He doesn't want to be associated with them, period. And even though he's going to do a speech apparently on January 6th, he wants to keep the election issues alive, but not be connected to the January 6th event. Occasionally, he has said he's spoken out for them, but it's just been very, very okay. He clearly isn't going to lift more than a finger for it. He's busy on his tour. He's busy on his old man's tour with Bill O'Reilly, praising vaccines at the moment. I mean, he sounds like a guy that needs to check into a nursing home rather than run for president again.
Oh, you're gonna make me pee in my pants because I have to go to the bathroom. I'm gonna ask this question. I'm gonna run to the bathroom, take myself out, and then run. It'll be no more than 2 minutes. Robert, people are wondering: is Trump going to run in 2024? Is DeSantis going to run? Is there going to be a battle between the two, or is there going to be a reconciliation and an assistance between the two? I'm going to take myself out. Please carry me over the amount of time it takes me to get to the bathroom and back. Go for it.
No problem. So to sum up the exclusion, expulsion grounds, they need 2/3. They only need a majority to exclude. They need 2/3 to expel. The U.S. Supreme Court made clear they couldn't abuse their expulsion power by redisguising it as exclusionary power. And so the 14th Amendment Section 3 likely requires that they expel, which means they need more than 2/3 votes. They're not going to get that. That's issue one. Issue two is that the grounds for expulsion, according to the only law on the issue with the Supreme Court justice, while it isn't binding, it's clearly persuasive precedent, which is that they need to be criminally convicted of insurrection or rebellion first before they can even be removed from office on those grounds. And even then, there'd be a separate due process proceeding that likely needs to involve the executive and judicial branch, which is not available. That's not what Mark Elias is discussing. And so that 14th Amendment stuff is a bunch of gibberish and a pipe dream that's not going to get anywhere, in my view. It's just one last-ditch effort to try to salvage 2020 Two, on the grounds of using the January 6th proceedings as the political cover to do so. And they still want to go after Trump, but they're looking now not at that as the focus to go after Trump, but instead the New York Attorney General and the Southern District of New York and the Manhattan DA. That's Trump's greatest exposure point. It's no longer January 6th legally. Politically, his greatest exposure point is in his interview with Candace Owens. He voiced a lot of opinions that are not popular with parts of his base. He came up with a kind of a pitiful excuse for why he didn't pardon Julian Assange and why he didn't pardon or help out Edward Snowden. He also didn't really explain why he failed to declassify a bunch of materials, not only concerning the JFK assassination, but just concerning his own Spygate investigation that he had promised to do. He kind of gave a weak answer. And then he was under the impression about things related to the vaccine that are very much in dispute, and he appeared to be unaware that such information even existed. What Candace Owens said later was she said that she thinks today Trump gets all of his information from mainstream media, that he pays no attention to independent media at all, including even places like the Daily Wire and Breitbart. And that he really believes a lot of things based on, because the only thing he's digesting on a daily basis, other than Fox, Fox you could maybe say is outside the establishment, but if it's not on Fox, Donald Trump doesn't know it exists. Or if it's because he's reading the New York Times, that's where he's at. And that I think that politically showed, a lot of people were shocked by the Candace Owens interview, because it showed what some of us have been warning about, that Trump is completely disconnected politically from his own base, that's what not being on social media has reinforced for Trump. The best thing for Trump on social media was not his voice on social media. It was him hearing from his base on social media. Yeah. He doesn't hear from them anymore. He's locked away down there in his beautiful place down there in Florida. But that you don't get connected to ordinary people that way. He gets some pushback on his old man Bill O'Reilly tour. I mean, you couldn't ask for a more senior citizens tour. God bless. But I mean, it's not. So it's not a surprise he's out there saying crypto is dangerous and bad. It's like, okay, this really sounds like Grandpa, get off my lawn. Well, and it's not the kind of Trump that is. People say, "Well, I can't wait for him to run in 2024."
It's almost reminiscent of what Hillary Clinton, and when you are remotely associated with Hillary Clinton, that's a bad place to be. Oh, you know what, Robert, and I'm going to go back and watch what you said. I think I heard it from where I was. Does Hillary Clinton run again in 2024?
I mean, there's rumors of it, but I can't imagine that. I mean, but it shows you the lack of base, the lack of backup, lack of a bench that Democrats have, which is partially due to the Clinton Foundation taking out potential competitors. But I think, these January 6 cases are so heavily political, but they transition into the really big political cases coming up next week. Is it next week? Yeah, I guess, or January 7th, which maybe that's another Monday away. But basically, the U.S. Supreme Court has decided they're going to hear all the Biden vaccine mandate cases at one time. And they're going to hear the Medicare mandate case and the OSHA mandate case, but from multiple parties. So I think they've set aside 2 hours for oral argument. My prediction is still that it's going to be 5-4, 6-3 to strike down Biden mandates. Biden seems to be implicitly admitting this himself. And before he took off for Delaware for New Year's, basically he said, "Hey, the federal government can't control this stuff. Anybody? That's up to the states." That's kind of a giveaway that even he knows he's going to lose on his mandates before the U.S. Supreme Court. But the big argument's January 7th, and that will if they affirm those mandates, then all the mandates are going to probably get upheld. If they shoot down those mandates, then it's probably a crack in the dam that floods and affects all the other mandates. So the legal issues don't require that they rule on all the mandate issues at the same time. Technically, this is just about whether Biden has the power to do what he did.
Okay, so and the broadest of the questions is, does Biden have the power to do it nationally, federally?
Yeah.
And they're going to hear that on the merits.
Authorize it? Was this an appropriate use of executive authority? Do you have to comply with the Administrative Procedures Act? Do you have to comply with other federal laws that govern and restrict how these rules are implemented and administered? And even if you do have all of that, does the Commerce Clause, the non-delegation doctrine, other things, do they give the federal government this power at all? If the court had courage and conscience, it would say the federal government has no power to mandate vaccines, period. End of story. That even Congress doesn't have that authority. I don't know if they'll have that degree of courage. I think they'll say the Biden administration did not have the authority under the statutes available to them to implement these vaccines. But they understand they need to deal with these issues broadly because there's the Medicare mandate vaccine, the OSHA mandate vaccine, the mandated vaccine, the federal contractor mandated vaccine, and the Head Start mandated vaccine. And what's interesting is the Head Start vaccine mandate, I believe, has already been enjoined. The federal contractor mandate has already been stopped by federal courts nationwide. The Medicare mandate has been stopped in half the states. The only one that's currently in force is the OSHA mandate. Even though of the judges to discuss it, 20 of the 25 judges who looked at it said that this shouldn't be allowed to be law. But it's by the weird coincidence of which panel happened to get it that it's even law. And rather than go back en banc to the Sixth Circuit, they want the U.S. Supreme. Everybody involved said, screw this. Let's go right up to the Supremes. We need a nationwide ruling. And it looks like this. And what we predicted was that they would take this, that they would need to take this, and they did.
And the thing is, they're going to take it. It's going to be, 3 hours? It's not going to be like days or weeks. It's going to be
2 hours of oral argument. All the briefing will have been done this week. All the final briefing that's in. There's amicus briefs. There's tons of parties from all over the place. You got hundreds of briefs that are being filed. This will consume the court's time for the next 2 weeks. And the big question, I think Gorsuch, Alito, and Thomas will definitely say Biden does not have this power. I think Kavanaugh will agree with him. So the only open question is Barrett and Roberts. And I think both of them may actually say the Biden administration doesn't have this power. I think at least one of them will.
Okay. And by the way, when I said, I won't say the letters again, but I think my phone thought I was talking to it and I missed what you said, but I think I made out what you said. James says, what about his family? They are all on social media. I don't know what you're talking about, James, but I don't want to ignore the chat. Thank you very much. But Robert, okay, we're an hour and a half in, and we haven't even gone to the headliner.
We might mean Let's Go Brandon. The Let's Go Brandon guy was all over social media.
Oh, yeah, well, but this is the other thing. There's an issue there about whether or not the information is out there versus whether or not it gets amplified by people with millions.
And highlighted, and what makes it newsworthy? Does it make it newsworthy that how many kids he has? Is what his kids' names are? Is that really newsworthy? It doesn't strike me as newsworthy. If he was a politician, maybe I could kind of see it, but I just don't see how it was newsworthy. I mean, the same media that said Ashley Biden's diary is not newsworthy is saying that Let's Go Brandon guy where he works is newsworthy. I don't quite see that.
Well, see, they're going to unanimously uphold. The next election will be fortified differently. Memento mori.
That would be a black pill mindset. But I'm highly. You can predict this by how many lower courts have been involved. The Court of Public Opinion matters, and the other courts matter. And if you're Barrett, if you're Kavanaugh, if you're Roberts, you've seen 20 of the 25 conservative judges look at this and say there's no way this passes any level of scrutiny. And so, are you really going to go up against all of them? Are two of those three going to say all of the conservative legal academy is wrong? Especially Roberts, who said he's wanted to undermine and want to limit Commerce Clause power. This is the best case to do that. Barrett, values the perception she has. She likes people to believe that she's a female Scalia. Does she want to completely gut that? It's one thing to be for vaccines, one thing to be for vaccine mandates. It's another thing to say the Biden administration has this authority. So I think there's very few conservative judges who've gone along with that. Very few. Now, one of them happened to be on this Sixth Circuit panel. But otherwise, and these judges don't come from that background. So they're judges to worry about in the vaccine mandate in general, but not to worry about, I don't think, on religious objections. I think both Barrett and Kavanaugh will come around. They'll say that you have to accommodate religious objections in the vaccine context. I'm banking on that heavily in a lot of ways. And so my money's where my mouth is already. But I think the same will be I think the OSHA mandate and the Medicare mandate, and the Head Start mandate, and the federal contractor mandate will all be struck down by the U.S. Supreme Court.
All right, man. Well, fingers crossed. I'm looking at the ring lighting thing. It's a camera. From your mouth to God's ears, Robert. And if anyone sees what I'm doing here, I'm not stroking myself. I'm stroking what is keeping my groin warm, which is almost just as bad. But Robert, we're an hour and a half in. We haven't gone to the headlining stories. Kim Potter. Let's talk about Kim Potter. Speaking of black pill moments. So I remember exactly where I was when Rittenhouse was acquitted. I was on the stream with Nick Rekieta, and the invoice, but I remember where I was at a store, which maybe one day I'll talk about. I remember where I was when Kim Potter was convicted, and I felt genuinely sad. And genuinely sad not because I have no remorse for Dante Wright. Not because I don't feel, but you play stupid games, you win stupid prizes. I said the same thing for Ashley Babbitt. Circumstances totally different. But Kim Potter was convicted. And you're going to have to explain this to people because I've had my troubles understanding it. She was convicted under first-degree manslaughter and second-degree manslaughter. And the question is this, under Minnesota law, what does manslaughter mean? Because my understanding is it implies a recklessness and not negligence.
Right.
And so
constitutionally it has to.
Okay. Explain to the world why this is. I know how you feel about the decision, so explain how you feel, but then explain why this verdict is bad. No other word.
I think it's problematic in the sense that the state is trying to loosen the mental state required, the mens rea is what it's called in the law, to convict people of serious crimes. Because a serious crime, you can do, the average sentence she would do is 7 years. The state has already said they're going to seek double-digit years for her to make an example out of her. And so the concern is that what happens when they lower the legal standard that you can be held responsible for a serious crime where you didn't intend the outcome. You didn't even know of the possibility of the outcome. Because that's what a strict liability or negligence standard would be. Whereas, and the reason why we've always required recklessness or higher is because we say that there's a right of due process implicit is that you will not be criminally punished in America unless you intend a very dangerous and scary outcome. So that's typically what in the homicide context, that's what we require. So criminal recklessness is, I know there's a high risk of death here and I did it anyway. I may not have intended the death to occur, but that's the traditional historical definition of recklessness. Now, this judge played loose with it, allowed the prosecution basically in rebuttal to kind of argue that negligence was recklessness. Their whole argument was always simple. Their argument was she pulled a gun when she said she pulled a taser, hence she's responsible.
No.
If he had pulled a taser, the person doesn't die. That was their the counter to that by the defense was, one, she was legally entitled to pull a gun. So the fact that she tried to use less force shouldn't be used against her.
And by the way, so no one accuses me of straw manning. That was not admitted evidence. That was an argument by the defense. The prosecution would deny that. They would say she did not have the right to pull the gun anyhow. There was no risk of imminent harm to the other officers.
They didn't really establish that, I didn't think. The expert testimony and the testimony of the government's own witnesses, the other cops, was that she absolutely had the right to use deadly force. They really focused on, she said she was going to use a taser, so the fact that she didn't mean she's responsible for the death, even if she was legally entitled to use the gun. They didn't really flesh that out so much, as far as I could tell. They decided to make it simple. Taser was supposed to be used, wasn't used. She said she called it, she didn't. Guilty, end of story. Whereas the defense was she could use a gun, so if she could use a gun, she can use a taser. And number one, number two, it wasn't criminal recklessness that she used a gun instead of a taser. So that was their bifurcated defense.
The argument is that she pulled the gun, so it was reckless to have pulled the gun instead of the taser. The argument is that she didn't know she pulled the gun.
Right.
She thought she pulled the taser. That's why she said taser, taser, taser. Then the flip side argument is it was recklessly negligent to have accidentally pulled the wrong firearm. And that's why I have the issue. Is like it was a bona fide mistake, and then negligence versus reckless, which would be like, I know I'm pulling a gun, and what happens is on me. Versus I genuinely thought I was pulling a taser, and what happens is beyond my control because I made a bona fide, genuine mistake that nobody contradicts. And that's the issue. Is dog hairs everywhere because I'm petting the dog. How do you get? My understanding is that everyone understands this to be negligence versus recklessness, and nobody understands the difference.
Yeah, I think
including the jury.
Yeah, my view is, given the speed with which they convicted on the first manslaughter, we found out later that they had convicted on the lower level manslaughter very early on, and the only debate was the top manslaughter count. It suggests that, what we talked about prior to trial, the open question is, could you get an impartial jury in the Twin Cities? And I had doubts that you could, because of how the Chauvin trial went. Not just how it went, but how the jury determined it. The complete lack of meaningful jury deliberation, given the serious legal and evidentiary questions that were raised in that very long trial. When you come back that fast, it's a sign that you had convicted him, but that when you sat down. And it appears that's exactly what happened with Potter. They had convicted her of something by the time they sat down in that jury room. And no matter how weak the prosecution, no matter how strong and robust the defense, no matter how much better the defense experts were, it didn't matter. And it's something that I've hammered home to people forever, but not enough lawyers take it to heart, which is, what matters the most is who you pick in the jury. And what you don't want to be is in the middle of the Rittenhouse case and beg for a new trial when they've already acquitted your client of 3 of the 5 charges because you don't have a clue who's on that jury.
I would have jumped on that if I were prosecution in a heartbeat. But I want to bring up Machiavelli too, because I don't know if this is a defense or an attack, but it doesn't really matter. I think it's more of a defense for her. She's right-handed, though, and her weapon is on the right side. So I don't know if that means policy or whatever, like you're supposed to have the less lethal weapon on your less dominant hand. I don't care. I saw those 2 weapons. And when people say, well, one weapon, the taser weighs a pound, and a fully loaded Glock with 17 rounds weighs 2 pounds, and one is yellow, but one is black, as far as I'm concerned, irrelevant. When you are in the heat of an altercation of resisting arrest and people's lives are on the line, you peddle confusion, to use Nate Brody's analogy. I don't care that one weighs 1 pound. We're not talking 10 pounds versus 1 pound. We're talking 1 pound versus 2 pounds. We're talking yellow versus red, black, where by the time you notice the color, it's been fired. So I'm going to take it off. But the question is this, how did anyone think that to say that it was reckless implies the knowledge of the risk? Am I wrong in that?
Yeah, no. I mean, I don't think they... she's a cop. She shot a black defendant who was unarmed at the time and said it was a taser. End of story. I don't think they thought it through any longer than that. Because, almost everybody that reviewed the trial thought that the prosecution was weak and the defense was strong. They had maybe criticisms